Hi everyone, this is Arkady Frekhtman. I'm a New York City trial lawyer, personal injury trial lawyer, and today I was actually reading the newspaper, the New York Times, and I thought this was an interesting article right on point where it says that Uber is facing sexual assault litigation and it pushes a plan that may curb the lawsuits. And it's really a question of tort reform or proposed tort reform. Uber drivers often will sexually assault women in the cars, either in the car or they'll follow them and do it like in a hallway, in an apartment, lobby, wherever. But it's a terrible thing. And Uber, instead of doing something to stop this, right, such as do background checks on your drivers, install something in the app where you could call for help immediately or be safer. I mean, maybe they're doing a little bit of that, but instead of like fully committing themselves to safety of their passengers, what they are doing is they're flipping it and they are contributing $5 million to a PAC, a political action committee, to start a lobby and present a measure in Nevada, like Las Vegas and the whole state of Nevada, to limit lawyer fees to 20%. And they think if they limit lawyer fees to only 20% instead of 33%, lawyers are not going to take these cases because it won't be financially advantageous for them to do so. Because a lot of these cases may involve hiring experts like psychotherapists, psychologists, forensic toxicologists, depending on the case. You might have to spend a lot of money. You may spend $50,000, $100,000. There are even some lawsuits where the plaintiff's lawyers are spending $1 million or $2 million just to prosecute the lawsuit, just to get the lawsuit to trial, spending $2 million of their own money. Now, you're not going to do that if your recovery is only 20%, right? So they're trying to limit it that way. The other way they limit it, which isn't really part of this article, but I know it, is that they force you into arbitration. They say that if you are using the Uber app, well, that usage of the app means you consent to arbitration. And the arbitrator is going to be with the American Arbitration Association, AAA. They're going to be much more conservative than a jury. So if the jury were to allow for $100 million, let's say, in a terrible rape case, the arbitrator may say, okay, it happened, but this is worth like $500,000, right? Huge, enormous difference. So and they say this PAC, this PAC, they're presented a measure as a way, and they say, to protect people from trial lawyers. Like, it's like silly. What, do people really need protection from trial lawyers? To protect people from trial lawyers who are, quote, getting rich at the expense of plaintiffs and everyone else. But that's really not true, because the trial lawyers are risking their own money, risking their own time, and they're helping these victims that are being raped, like in this case, or even if it's a car crash with an Uber and you get seriously injured, you have like a traumatic brain injury, a fusion, a fracture with surgery. How is the trial lawyer getting rich off of you? I mean, if they're a real trial lawyer and they're willing to go to court, willing to spend their own money, they're helping you, right? Without the trial lawyer, you would not be able to get, let's say, $3 million. And the trial lawyer may need to spend $100,000 to even step foot in the courthouse. And how would you do that on your own? Would you spend $100,000 of your own money? Are you a lawyer? Were you able to go to court yourself? No, right? So effectively, the trial lawyer is your access to justice. It's your door to justice. And without the trial lawyer, Uber, who's a huge billion-dollar corporation, could just laugh at you and say, oh, you got hurt, too bad, so sad, how about $500? And what are you gonna do? Are you gonna take it or are you gonna get zero? So I don't see it, but that's what they're doing. And they pushed another measure in 2020, and they were actually successful, because back then there was what they called gig economy. And what they did was there was a proposal in California that classified Uber drivers as independent contractors, because then they're not eligible for benefits. And that succeeded. And that was the most expensive measure or proposal in the state's history. Uber spent $200 million to push that through. So you see what Uber's doing, and I think it's really terrible, because on the one hand, if they really are concerned about this, whether it's sexual assaults in their vehicles or whether it's just car crashes with serious injuries, they could be doing something to promote safety, to vet these drivers better, so there's no negligent hiring, no negligent retention, no negligent supervision. They could improve, right? They could have safety measures. But instead of doing that, what they're really doing is they're trying to lower the legal fee to 20% so that people can't sue. So they're effectively trying to block your access to justice. And they're trying to, block your ability to go to court and speak to a jury by saying, oh, how about we do an arbitration with this conservative judge who's 70 years old, who's been working for the insurance industry his whole life. He'll give you justice. Yeah, he'll give you like 2 cents on the dollar if you're lucky. It's just terrible. So yeah, so if you live in Nevada, go out and vote against this measure, because I think it's on the ballot probably this fall. And it was in yesterday's New York Times. So I just thought it was interesting. I wanted to do a quick video about it because it really relates to tort reform, and it relates to all types of personal injury cases. And really, I think it's an access to justice issue, and it's a Seventh Amendment issue, because in the Bill of Rights, you have the Seventh Amendment, which is the right to trial by jury, and they're effectively taking that away from you, because the only way you can have a trial by jury is by hiring a lawyer. Well, if you remove the lawyer's compensation, the lawyer's not going to do it for free. Now you don't have a lawyer. Or if you say, well, you have to go to arbitration, well, then how is that? You're also removing your ability to go to court. And, different courts have interpreted that arbitration clause in different ways. I believe like Massachusetts has struck it down in some cases. New York actually, unfortunately, upholds it, because it says like it's almost like a contractual thing if you agree to it. But you don't really ever agree to it. And maybe it's the fine print that says, oh, click here to use the app. And no one reads that fine print. It's like 20 pages. People just click, okay, I click this, acknowledge this to use the app. But somewhere in there is buried that you agree to arbitration. And I'm sure like not even 1 out of 100 people read it, but for whatever reason, the courts have upheld it in New York. So it's unfortunate. But let us know what you think. Please like and subscribe to our channel. We are here for you. Our goal is helping serious injury victims and families. And if you have a case, whether it's Uber or any other type of case, you could text me 347-566-9595. I just ask that you include a brief statement, 1 or 2 sentences about the facts and the injuries, and then we could schedule a free confidential call where we discuss everything. And I'm happy to help, whether it's in New York or all over the country. I could partner with excellent trial lawyers, the best trial lawyers who have had record-setting $1 million and even sometimes hundreds of $1 million verdicts. And then we work together to get you justice. Okay, everyone, have a great day. Bye-bye.